Okay, maybe we'll get things underway. So welcome to the second day of the Asian Corporate Law Forum. I think we got off to a absolutely wonderful start yesterday, and in the afternoon, right, we had a number of papers on ESG, and it's sort of interesting because those papers came in, of course, pre-Trump, right? So it was interesting, I think, to see. I wonder if in a year's time we will get in so many ESG papers will yet to be seen. But today, this morning, we have two papers on AI, and I was just chatting with people about how AI, of course, is something that it's not only involved with technology and corporate governance, but I think it's touching each one of our lives, yeah? And even in our panel on shareholder activism later, when I think of China and you think of DeepSeek, what this did to the financial markets, it's incredibly important. So with that, I will hand over the time to Poomsiri, who will be chairing our first panel with a paper on AI. Thank you.
Okay, so good morning, our last day today. But I see some new faces, so welcome to Chulalongkorn. Our first session today, we have Akshaya from ANU as our presenter. We also have Tomoyo from University of Tokyo as our commentator. And the topic for the first session today will be corporate governance, technologies and the law, perspective from China and India. Very interesting topic. So without anything further to say and to have a lot of time for our presenter, let's hand this to Akshaya.
Thank you, Poomsiri. Let me start by thanking Dan, Poomsiri, and Vivian. I'm very glad to be here, and I think my co-author couldn't be here, but Associate Professor Lin from NUS and I are both very pleased we got a chance to workshop our paper here. So to talk a little bit about how we came to thinking about this paper, I'm currently working on a book called Corporations, Technology and the Law, and one chapter in that book is called Corporate Governance and Technology. So I was sort of thinking about how this would work regionally in Asia, and when I spoke to Lin, obviously a co-author brings fresh perspectives, and so we sort of thought about how corporate governance, or rather the broader title of Corporations, Technology and the Law, from a corporate governance perspective, how is that playing out in India and China? And so this paper basically starts with this broad idea of today technology is being used maybe in the process of corporate governance, but just in many other ways. So companies are making AI tools, but also using, creating applications of lower tech applications that stores data, etc. But companies are also deploying technology made by other companies. So we sort of got into this picture of thinking about what laws and regulations are out there for companies to follow. But that's really not the core of the paper, because like I was, I think somebody, Kenneth said yesterday, the core area of corporate law is to think about directors, shareholders, relationships with the company, and not too many other things. We have labor laws, we have environmental law, we also have now legislation on AI, data protection, etc. But corporate governance has crept into other areas simply because these other areas of law maybe not, they exist as a sort of compliance requirement for companies, but corporate governance is pushing companies to prioritize these other areas. And now technology has become really important, and although our paper was written, we started thinking about it pre-Trump, but we continue to think about it post-Trump. So I think now it becomes, when you're thinking about AI and technology, we are sort of, and thinking of China and India, we justified why we're thinking of these two countries, saying, hey, China is this other big country in the arms race, like how it was with space in the past. Now it's an arms race for AI between the US and China. And then there's India with a lot of ambition in the context of AI, and a lot of foreign investments and collaboration on this. So these are countries to watch out for, and we sort of came to it in that way. But when you're thinking about regulating AI, we usually think about the two big models of the US and the EU, where the US, because of this arms race I spoke about, wants to make it a free for all and wants companies to be able to do more, innovate more, whereas EU seems to pride itself on being a regulatory entrepreneur and exporting its regulations to the world. So when we think of companies in China and India, we should not only think about the local regulations, but we say repeatedly in the paper that companies have already started to comply with the EU regulations on data protection, the AI Act, so that exists in the background. With that introduction, to why we looked at China and India, let me say very briefly how we approached it in terms of the method. So we sort of looked, to an extent, it's a bit doctrinal that we're looking at what the laws, what laws there are in the two countries, but we're also going beyond that and looking at the public policy element, because, and if you've looked at corporate governance research on China and India, which does more political economy type thinking, you'll see that politics and public policy matter a lot in these two countries, even beyond the law. So we look at hard law, but also public policy that may be giving clues in terms of soft law. And then we have like a brief sort of, we can't call it empirical, although maybe since Kenneth is not here, I can say it's empirical. Maybe it's an exploratory study into looking at how companies are, what the practice of corporate governance is. In terms of all these different legislation around AI and data protection. Now, we've restricted ourselves to AI and data protection when we're thinking about technology. The broad title we use is digital governance, which is a phrase I use in my book as well, but the book has a broader ambit. This is about AI and data protection because that's the two big things going on. Now, in terms of, to get into what's going on in the two countries, so there is, we first of all looked at what's happening in terms of companies using AI in corporate governance. There's a lot of that happening in China, not so much in India, so maybe just different stages in the life cycle. And you would have all seen this Hong Kong firm many years ago that came up with a bit of a gimmick saying they've appointed an AI director on the board. While that may not actually be the case, there's still sort of, the board is using AI in risk management, figuring out risks through contract review, all of this. Interestingly, and in line with the theme of this conference, in China, there's a push for the SOEs to engage in ESG practices with the use of AI. And we have some examples as well in the paper. In India, it's happening more from a public policy push. There's something called Niti Aayog, which is this like a planning commission. But basically, there's a policy push from the government to, they call it AI for all. So they want to make sure that different parts of the country are not left behind. And interestingly, from a corporate governance perspective, a lot of the foreign companies, the big tech, Meta, OpenAI, all of these coming into India are doing so with partnerships with the government on terms of some sustainability projects. So that sort of the sustainability aspect of it seems to be built into public policy in both countries, and the way it seems to be the lens with which you view sustainability for AI in these two countries is to see companies that are of that country, or in India even the foreign companies, to be involved in this project of nation building by engaging them in these practices. It's also interesting that there's a lot of law and policy both in China and India, but particularly in China there's also regional laws which are more about encouraging the use of AI by companies rather than to sort of put checks on that. But there are also laws to say, you need to form ethics committees, you need to report on this, and the new company law in China actually mentions that you should have a board-level committee to look at AI use. While India doesn't have these things on paper, in practice, you have companies employing a number of chief technology officers. There's a new law on data protection that's taken effect at the end of last year or beginning of this year, which requires them to have like a chief information security officer. So there are these things coming into the practice of AI governance or digital governance. There are a point I should stress, because we mentioned Trump, but even pre-Trump, a lot of countries have been very concerned about digital data sovereignty, so to ensure that companies store data within that country, data about their citizens. So China has clear rules about this. India has a more liberal approach, but then there are some sectors where they do insist on data localization. So with this sort of broad, I've given you sort of a broad brush of what we have in the paper in terms of the law, soft law policy. The takeaways, if you think about, there's these two countries we're specifically looking at. We're looking at it from a corporate governance angle. What new and different insight can we draw from it? My first sort of the idea you get when you look at all these practices emerging is that, hey, it's not that different from companies in the West that are trying to have, a chief technology officer, some sort of disclosures. So I didn't mention, but there's some disclosures in both countries around what they're doing with digital governance. But there's actually more to the story, because there's a lot of like I said, the public policy and the encouragement to deploy and develop AI, it plays a big role. So when I look at the literature, overall, like there's this paper, The Tech Nirvana Fallacy by Luca Enriquez and Dirk Zitsche, which gives you this sort of broad outline of here's the role of the board, it's the monitoring role, and from there we proceed further and think about what happens with technology in play. What I get from looking at the India and China story is that perhaps there's more weight to be placed on the strategic role of the board, and the resource dependence theory basically talking about the board's ability to bring in networks and contacts, right? Now, both of these seem more important here, because when you have a government push towards public policy, the public policy push towards deploying and using more AI, there is an emphasis on thinking strategically about how to bring in AI when the returns aren't immediate, right? It's for companies to invest now and wait for the returns. So there's more of the strategic role, and also the resource dependence theory, which highlights basically this theory is talking about networks in terms of bringing networks from other industries, other countries. Here I think it's important in the context of networking with the political environment in the country and outside. The developments around TSMC having to work directly with the US government in the past, Elon Musk's SpaceX working directly with the Ukrainian government. All this tells us that there's a sort of geopolitics element that company boards need to upskill about, and I put that under the resource dependence role of the board. And I guess in terms of challenges, our paper highlights a few challenges. Again, these are sort of universal. We talk about algorithmic bias, so the impact on employees when you're using AI tools to monitor employees, the impact on customers when you're using AI tools to engage with customers. And in India, you must have all heard about business process outsourcing, a lot of call centers that provide customer service to companies outside the country, and now these are being done by bots. So companies outside India are also sort of buying these services from Indian companies. So it's something that we probably need to think about from a corporate governance perspective, but also from supply chains if you're thinking about companies outside the country. And finally, I think I mentioned how politics and the public policy element probably plays a bigger role when you're looking at India and China, and I just want to say that this is not a particularly new insight. About 15 years ago, there was a book chapter by Hossin and Khanna talking about how law impacts a little, but politics sort of plays a bigger role in both these countries. And I think that's sort of continuing on with the digital governance journey as well. Did I have anything more to say? Yeah, so the final section of our paper wanted to sort of highlight that while we've given this different insight from India and China, we're sort of highlighting that the big challenges, apart from the ones I've mentioned that are universal, the big challenges of sustainability and geopolitics sort of have a very unique context-specific flavor for each country. And I mentioned how for India and China, the sustainability aspect probably comes into a sort of nation building focus. It may be very different for other countries, like with OpenAI trying to structure differently. These sort of experiments are unlikely in these two countries. And geopolitics, again, it depends on how much companies in these countries will engage on their own with other country governments. I'll leave it with that, and I welcome questions. Thank you.
Thank you. So, firstly, Akshaya, thank you very much for your fascinating presentation. I hope that I have to apologize before I begin my comment. As I provided my comment slide based mainly on the paper that you provided us beforehand, and that was about the international comparative AI law between China and India, and very fact-based. And I recaptured the basic idea and explained that main points from my view. But today you have given the presentation based on your observation, so there might be some difference. And I have to approach also because I am no expert of an AI law. So, and what I could comment is limited to some basic points. Anyway, I'll begin with the summary of your presentation. Okay. Before I proceed to the point, let me briefly capture the notion what you are discussing with the term data governance in your article. So you explain the notion like this in this excerpt, well, I've not read it aloud, you can read it yourself. So but that means in your article, the notion of data governance is conveying twofold meaning. The first is the merits and risks associated with the use of technology within corporate governance. There you talk about the inner risk and chance of data itself. For example, data can be dangerous in the sense that the hackers can steal or destroy it as a whole. Data or AI providers can distort the contents, and the government can introduce burdensome data protection requirement or ban the international data transfer. And of course, that has its chance, especially government has strong support policy on it. And secondly, data governance can also be something about problems occurring in the with the decision to use digital technology in corporate activities. And this, it's not about the data itself, but about the human errors that can be held liable if you go to court with it. And if you use the AI to reduce operational mistakes, that is hopeful, that is okay. But as you have mentioned, sustainability project is so complicated and ambiguous, so perhaps AI will inevitably fail. And in that case, there must be the problem is that whether the main source of the accident and damage was a defect AI or the human misuse. In the case of the former, it is a part of a problem of supplier liability or product liability, and that in turn can be observed at least partially as an innate risk of data itself. While the case of the latter, the misuse, the problem is more akin to the usual civil liability in a company directors. Based on that understanding, I have recaptured 3, if not 2, main points in your article. The third point is rather about the environmental factor that exacerbates the first and second factor. But anyway, let me explain the whole picture. The first one, the data security. We need data to feed AI. The basic risks can be categorized into 2 fields, domestic and international. And domestic problem, data like data breach, and data theft and information leak by hackers, ambiguous algorithm, and some kind of things like that. And the international data transfer issue is a kind of national policy, and you have talked much about the geopolitical risks about that. Now I'll just elaborate the problem in the later slides. The second problem is a second point is civil or corporate liability for poorly introduced AI and damage compensation. We have to have a clear view what the actual damage-inducing factor was. And the third point is then insufficient human resources supporting AI application at both the engineering and at the managerial level. If in-house engineers are not capable of checking the AI, how can companies avoid the risk of accepting ill-performing AIs? And if monitoring organs and managers are not capable, but still they stick to the arguments that they are not liable when AI fails because this is something what the AI have to the risks and the caveats, who can see through the situation and pin down the responsible party. So for each point, you have provided a Chinese and Indian explanation. For domestic data security, you explained that AI training data must come from the lawful sources and must not infringe on intellectual property rights or user privacy. In that context, China has introduced an enormous number of industry-by-industry basis regulation that to get rid of uncertainty and promote the industry, encompassing from data protection to algorithmic transparency obligation, while India is also now equipped with industry-based regulation with data protection best practices under working. And for international data transfer, the point is whether a government introduces regulation based on the idea that enterprise must conduct security assessment and mitigate risks before providing data to overseas entities. ensuring the lawful and orderly flow of data. In that point, the two countries proceed with a sharp contrast. China regulates the outbound data transfer, demand risk assessment, while India takes liberal approach regarding data localization, a transfer possible to all countries except those that are restricted by the government. Well, perhaps there are some other special regulations for the financial institutions and so like that, but basically it's free. And to the second problem, you said that the situation similar with China and India. This problem was not much elaborated in this paper, but to this point, I think, well, partially Steve will take care of it, so I will not talk about much on this point. But China is tackling the problem by having audit and risk management committee, the body that is responsible for internal control and disclosure. India, in turn, is appointing CTOs, chief technology officers, and you also provided numerical data on the recent cases of data breach report. So I just jumped to, excuse me. Yeah, I provided some information on the Japanese situation, but due to the time limit, I'll just jump the Japanese situation and proceed to the question. So, many EU, UK, or US countries have long maintained India transaction parties that operate as their outsourced customer service operations or the call centers, which helped the AI industry to flourish in India. But China has its own tech giants that can lay out domestic data center. It seems that China and India is adopting different approach to international data transfer and are thus belonging to different data flow sphere. Pure hypothetical case, because Akshaya told me that because of the relationship between China and India, there are no Indian subsidiary in China, but nevertheless, you can imagine it as Japanese company or something. Well, so an Indian parent company, IPC, wants a streamlined operation throughout the group companies with the use of an AI and needs the data of its subsidiary located in China. Will IPC decide that AI be used in Indian server or that Chinese AI in Chinese server should be used? No, that means that a data center should be located in China. On the other hand, if a Chinese parent company, CPC, wants the data of its subsidiary located in India, will CPC chooses to feed data to Indian AI at subsidiary's location? Well, my impression is that the company will choose the AI server in China because it's so costly to do the risk assessment and all that. So this means that if the manner of handling data is uneven across countries and undermines equal footings in data trade, won't this give rise to any problems in terms of free trade described in many agreements such as those under the WTO and EPA? What do you think the AI-related transactional data flow will be like in the future? So this is my first question. And the second question is that about the civil liability. Because in the previous slides, I said that Japan has a piecemeal approach about analyzing the civil liability of the AIs. Are there some academic discussions, even piecemeal approach ones, on how an AI-related civil liability should be distributed among incapable AI developer, poorly equipped data provider, business corporations that falsely applied AI to product, and customers that misused an AI programmed product, and insurers? Like there are so many parties who can be responsible of the AI failure, and there must be some design to approach this kind of civil liability. So I was curious about that. And the third question is about the corporate governance structure. My idea is that the Chinese type risk management committee is also an organ serving for general internal control and oversight. Also, I'm not sure, but I understand that the CTO in India is a senior executive officer who primarily is responsible for the execution of operations. So if that is correct, my impression is that the executor tends to act as an accelerator rather than the brake, and the auditor tends to stop things. So how do CTOs, and perhaps in that regard as chief compliance officer also in India, balance risk monitoring and execution? For example, if one board member recommends some data or AI provider and whose ability appears dubious but who might be bribing the said member, will CTOs be entitled to do the investigation to prevent the conflict of interest and something like that, aside from analyzing pros and cons of going into contract? So this is my third question. And thank you for the presentation again.
Thank you both Akshaya and Tomoyo. I think maybe first Akshaya can respond to Tomoyo.
Thanks, Tomoyo. That's very interesting, and you've made me think in different ways. I'll take the three questions, but before that, the way you summarized what we had was also useful to get that perspective. The question on international relationships, you put it in the context of data transfer. I think this is a big issue in the trade law circles, and that's why now they have data localization clauses in free trade agreements. But I think from a corporate governance perspective, what we want to think about is not only what the policy in that country is, but also the companies trying to have their own relationship with the other country they're doing business with. We've already seen this with a lot of US companies in China trying to have partnerships. I think they do it as research partnerships because they want to have their own good relationships in China, whether or not their government does. So I think we'll see more and more of these companies trying to figure out their policy a little around their country's policy, but then the rules in trade agreements will matter as well. And I wonder how much governments will start stepping in and saying, hey, this is a national security issue, so maybe you shouldn't. So that could come up as well. The second question on AI related to civil liability, obviously this is not something we have answers for across jurisdictions, but we have some examples of cases. One case from India in the paper, which isn't quite about directors' duties, but it's about using the image of some Bollywood actor to sell products. This was a deep fake. So basically it's an IP related case, but it holds that company liable for doing this. So in a sense, when there is no law, I think, or when there's a vacuum, it's corporate governance imperative for there to be a policy on how to forge ahead. Should you move fast and break things, or should you be more careful? So that's to that extent, it's a corporate governance issue, and I'm not sure, it hasn't been tested out as a director's liability issue yet. And then you had a question on, the third question I thought was interesting. Maybe we should clarify in our paper, because in terms of there is law in China on needing risk management committees on AI, there are no specific laws in India. But if you look at the practice of it in both countries, it's not very different, because both companies in both countries are thinking strategically of how to adopt and deploy AI. And then the disclosures in both countries do mention tech risks. And there's in that exploratory study from India, I found companies having AI policies, data security policies. So at least on paper they are telling their shareholders or whoever else will read, as we heard yesterday, not many may read those disclosures, but they are telling people that they have risk management processes in place. So I think in practice it's working out similarly. One reason for this could be that Indian companies have tended to sort of try and pick up on best practices from countries abroad. So maybe that's how it's sort of come in, but maybe the impending data protection law also sort of made companies to get into that. Thank you.
Just ask additional question. I'm sorry, just to clarify, is CTOs or CCOs in India an employee or sort of directors? What is the contractual structure?
Okay, so I think that would be company specific. Broadly, it's a C-suite position, but some of those companies that are having CTOs are sort of, it depends on how much power you give them in that company. So some new C-suite positions, like my earlier project on diversity, they used to appoint chief diversity officers without giving them too much power. So I think it depends a lot on how much power does that person get a seat on the board. It's very company specific.
So it depends.
Yeah.
Okay, thank you.
Okay, thank you so much. It's very interesting to see the perspective from the two biggest countries in Asia, right? From China and India. I think we read a lot about AI and regulation in the West, in the global North, the US, the EU, also in China as well. But we haven't seen a lot of literature from talking about India, so it's very interesting. And I think that you laid out quite very complete view from development or adoption to deployment and to the use as well. And I like the way that you kind of make connection to corporate governance, which is quite new and interesting. I want also to talk about the perspective on the same issue from different jurisdictions as well. So we, as a Asia Pacific, can have our perspective on different things in different way because we have different contexts, right? In Thailand as well, because the regulation, the law and regulation is still very at the very early stage. We're still developing a lot of things, and in Thailand we haven't have any set law or regulations. We have example from the data protections that we adopt the GDPR and make some little adjustment to that. But that didn't really work, I think. So there have been a lot of resistance, a lot of complaint from both public and private sector as well. So for the AI regulations, we take some more times and we considering what model we're gonna adopt. So right now, since we don't have any models, we kind of like make it very flexible. And we just let the existing law to kind of take over and regulate the AI as is, which might not be a good thing as well. No one can tell. And also you mentioned also about the politics, right? And for example, in my country, Thailand as well, the government make a lot of effort to attract investment from big company, right? And one of the target will be tech company. We've been getting some significant investment from the cloud computing company. They're gonna build a very big cloud and data center in Thailand. And I am also afraid that this kind of narrative or this kind of government policy might also influence how we adopt the AI law as well. So if we want to attract something, we really might be like have to make the law very easy for them as well, right? So that can be one thing that certain policies, economics policy can influence regulations. So this is my take, and I want to hear from everyone else as well, especially you guys from different jurisdictions. Any comment or anything anyone want to share? Yes, thank you. Yes, please.
Thank you for the presentation. I want to ask one question, maybe also one thought that, like, for example, in the startup space, given the recent kind of incidents, I think one of it, like Silingo in India, we also have something similar like eFishery in Indonesia. There has been a push for venture capital to basically deploy software in a way that software is somehow implemented in the startups, and they look at redundancies on accountings or markups and so on. So the question is that when, of course, the paper have looked at, how is data used and data privacy and so on, but I'm kind of more concerned on the repercussion. Let's say if, I don't know, it's like a malware or something like that put in the systems, and the VC says, oh, I want this software to be installed in all your laptops and your finance systems, SAP, whatever, and then it will give a real-time reporting every month. There's a board meeting. Oh, you have this score. Hey, you have this. It's like in academics, you have this Turnitin test giving you red flags, while in corporate governance, is this software giving you somewhat a report. Oh, there's this potentials of overlapping or duplications, or there's potentials of markup in a certain spending, and then there's need to be a board decision to address that, or special audit or something like that. How do you see that kind of system and AI system will affect corporate governance dynamics? Because I think one is not human, it's a software. Second, there's maybe false positive, as we can expect for software, even like Turnitin have that. And the third one, the dynamics is like a continuing supervisions by the investor or the shareholders that doesn't trust the founders, in my case, or similar like a state supervision. So that's kind of the thoughts I'm having on this subject. Thank you very much.
Thank you. So I think parts of your question deal with software regulation, which is not something we cover in the paper, but I take the broader point that what do you do with when there's a problem with AI management, right? Now, across jurisdictions, both in policy literature, but also academic literature, they talk about this thing called having a human in the loop. And I think at the moment, because directors of companies have certain duties which you can't get out of because you've outsourced something to technology, it's on, just like how in the past you had to have compliance systems and look for red flags. At the moment, you're dealing with something that can give problems that you don't anticipate, but it's the job of companies to actually do these risk assessments, anticipate problems, address risks, but you can't always prevent them. There have been, and that's one of the studies, the exploratory studies in terms of how companies are engaging their stakeholders when there has been an incident. So we basically looked at cyber incidents in India, data breaches. And I think there's been, in terms of, they do disclose, they do talk about what they're doing now, then there's information sharing with governments. So, you're managing different stakeholders. You're doing this separately with government, you're doing this separately with disclosures to shareholders, but you're also thinking about whose data was affected. If it was customers, they're not going to trust this company anymore, so you need to repair that relationship. So this is my very corporate governance-based answer to the question. I hope that answered.
Just to add one scenario that I can imagine with AIs, right? So in the normal, and this is maybe particularly in Indonesia, in the normal corporate governance, if you are non-executive director, or in our case, a commissioner, you will wait for reports, either like a monthly, three monthly, or someone from internal audit departments will give reports to you. What I would imagine with AI systems that installed there will be like dashboard with red flags. So even non-executive directors can have red flags every time there's something happens, and they have to, we have to have a meeting because the AI spots red flags. So there's something that I could imagine will be the dynamics of the board meetings in the next few years where AI will be the first responder rather than an internal audit or a forensic or someone like the Big Four. So this is something like, maybe more like boardroom dynamic in terms of corporate governance.
Okay, thanks. So I don't see this going straight up to the board immediately. It's the sort of thing we were speaking about with the CTO, right? So different teams now deploy AI, and then each of these teams have humans and AI working together, and they need to have policies on getting these human AI interaction to work out, and their management should make sure. So the mistake can come from AI, but the mistake can also come from humans interpreting the AI, or how they start to rely too much on the AI while actually they're put there to be the human in the loop to do checks, but they're not doing it. So this is some data coming out of non-corporate governance research, but I think I was looking at some in the UK Law Commission report on using AI in drones, but I think it's relevant to think of how human AI interaction works. So I think these are sort of management level escalations, and then the board is involved in as much as these things get reported, then they make an AI policy, they're trying to figure this out, but I see a lot of management involvement, and this is one of the challenges we highlight both in India and China. We say that there is a sort of, you would imagine these countries have a lot of skilled employees at these levels, but actually not, because to be able to find the right kind of skills to deploy AI, this actually is a challenge in both these countries.
Anyone else want to chip in?
I have sort of a basic and naive question, and I didn't have time to read your paper in detail, but I did sort of skim it, and I know that the conclusions you still haven't finalized yet. But I'm just curious, I'm a bit of a bit of a dinosaur in this area, and sort of tech and AI. But I'm wondering from like a sort of a classic corporate governance perspective, if you look at the development of tech and AI and data in India and China, what do you suspect? I know you haven't finalized your conclusions, but what do you suspect as sort of core corporate law and governance issues that will come out of this? In the sense that things like deepfakes and AI regulation, of course, this affects corporations and everybody, right? It's not a corporate law issue per se. So a lot of this sort of are issues that have to be figured out with technology and AI in general. But if you were to name sort of one or two things that you came across looking at India and China, that you really think from like a sort of a classic corporate governance perspective will be in tension or really affected by these, the advancement of technology and its regulation and data protection, what would that be?
Thank you. So I forgot to apologize. It's not for you to apologize to me, but it's for me because I didn't put in it was a very underdeveloped paper that I sent, and so the same goes for you. The last section is what we sort of have come up with in the last few days. Now, the classic corporate governance story, at least the received wisdom, would suggest that when you're looking at India and China, if the problems identified in the West have been about the monitoring role of the board and how shareholders can hold them to account, and the solutions have been about disclosures, you would think that, in other contexts, when you look at countries like India and China, maybe it's an issue of controlling shareholder versus minority shareholder dynamic. This might come up in the future when the monitoring role of the board really becomes that important in this context. But I think the corporate governance and maybe less on corporate law, but corporate governance issue that is the takeaway here really is that at this stage, both countries have a huge sort of public policy push, and because of that, the board's role is less on monitoring, more on strategy, and more on the networks. So I don't know, it's not probably giving you much on corporate law, and I'm sort of avoiding saying these will be the corporate law developments, because like I said in the answer to the third question, that there is the new company law in China specifically said you need to have a committee looking at AI risks. We don't have this specific law in company law in India or any soft law, and yet it's happening because of the sort of corporate governance practices in countries out of India, and that's influencing them. So yeah, I have no predictions on how the corporate law will evolve, but we see corporate practice evolving in a way that's not very different from the West. Maybe it's just these other relationships, the resource-dependent stuff that I should highlight.
Yeah, I guess just to push back a bit further, like if I think of AI risk, I find it a bit curious, right, in the sense that companies have to deal with risk management anyways, right? So the question would be, how's that committee going to be different, right, than any other risk? I understand AI is another risk, but is it materially different? You know, that's what I would be interested in. I don't know the history of the Chinese law, but the question is that committee going to work any different than any other sort of risk? And then if you say, well, the difference is between controlling shareholders and dispersed, then I think, well, what can AI do and stuff? Are you talking about that somehow AI is going to be used as a better tool to, say, figure out when there's a difficult related party transaction, and that could be more beneficial to countries with controlling shareholders? I don't know that, you know, I guess there's certain types of RPTs that are less easy to detect traditionally, right? These sort of repeat RPTs. Maybe there could be things along that line. But I'm wondering, are you thinking of going in that direction, or does this seem totally off base?
So the answer was, like, to your first question was no, that it's nothing different to say that you need an AI risk management committee. And this is why I haven't emphasized that, hey, China has this, so India should have it, because I think that risk management is a core corporate governance aspect anyway. So you can come up with more specific regulations, or you may leave it to companies to do it. That's why the innovations or the information we sort of got out is more on the practice of corporate governance in the AI space, because the main ideas aren't that different. You still have to look at risk management. And I'm not that sold on related party transactions being caught better by AI unless you find, I don't know, somebody comes up with a way that AI is detecting this. At the moment, what I've heard is only at the regulator level, that they're using AI to pick up on, I think this was in Hong Kong, where it was, I don't have this as a source to cite to, but this is someone at the regulator who told me that they're using it quietly to check on related party transactions, to look at, not related party transactions, to look at loans from related parties, something like this. And even that, it's just helping speed things up. It's not finding something that you wouldn't find without AI, which is why it's not a fundamentally new thing, so we haven't actually put that into this paper.
Okay, please.
So that's very fascinating presentation. Just a follow-up question. I personally really interested in AI development, so I asked some of my friends. They work in the AI company in China. There's some algorithm engineering or AI scientists, and I found that we may have different levels of risks in the world. Like they have the technology level risk. It means that if you may have some risks in the algorithmic development, the AI scientists actually they can have some technology thing to control that such kind of risk. And then we may have the corporate level, which means that some corporate services or products may harm its customers or so far and so forth. So they can control the risks of at the corporate level. And we may also have the whole level, like harm the whole society. So we also have the different level, right? The high risk level, medium and low levels. I just think about, let's recall what happened in the last century when the companies, they compete with each other on a nuclear weapon. And at the end, they found it's very terrible, and every country just stopped that thing. They want to control such kind of risk. I think that kind of would that also be happen to the AI? And what should we do in company law level? Because we still have the different multiple levels of AI risk. Yeah, I just want to hear about your thoughts. Thank you.
Thank you. So I know that some countries some jurisdictions, including the EU, have these labeling sort of high risk, low risk. And I think all companies now this is like a compliance issue. All companies have to, if you're deploying AI, in certain, if you use it for something that's labeled high risk, then you follow something more. So that's a compliance issue. I just don't compare this to nuclear arms race so much. I compare it more to the space race, because the space race sort of allowed for a lot of innovation on both sides, because there was that incentive, governments were putting money into it. I compare it more to that. But in terms of specifically the societal risks, I think we'll see more regulations, whether, if it's a country that will regulate or a country that will let the judiciary deal with it through case law. These sort of things will sort of, the broad brush first principles from various private law areas will sort of come in and sort of sort out a number of issues. Maybe insurance will come in. But I think the corporate governance questions that I think are interesting at this stage before all those laws are settled are for how companies anticipate risks and anticipate legislation before it comes. And this is not different for India and China. In the chapter in my book, I talk about John Armour's idea of, forward compliance. So thinking of future laws that will address technology, and then companies sort of, the companies know the risks best, because regulators don't know what the companies are doing internally. So we hope that companies will comply with a law that may come up in future, because if they don't, as right now when we see data breaches, they're having to face their stakeholders and explain what went wrong, so there's a reputational cost there. So that's the sort of corporate governance issue I'm getting at this sort of time before the laws are well settled around AI.
Okay, so I think we are almost on time. Let's have a round of applause for Akshaya and Tomoyo.